Father, we come before you, Lord. We adore you. We respect you, King of Kings, Lord of Lords. We pray, God, for a good class for the next 2 hours. Give me wisdom to guide the participant and the student as they prepare for the exams. Be with them. Guide me, give me more clients, subscription to the website and to the YouTube channel views. I pray all this believing in Jesus Christ, my Lord and Savior. So we are going to give you some question. To tackle. Of course, I want us to deal with it, at least deal with all the topics in criminal litigation this week. And even if a question has not been tested, I do a mock drafting so that we can see how we are going to do it. Because a topic, if it has not if a topic has not been tested, that does not mean it cannot be tested in future. So I try to look at the possible question that can be asked in drafting, which means also you can be asked your question on the same. So we start with question 1, which I hope you can see my screen. Conflict broke in Darfur region in Sudan for many years as ethnic groups rose against each other. In 2012, the UN Security Council passed a resolution inviting the International Criminal Court, here should be read Criminal Court, ICC, to investigate the atrocity and bring to book the people who planned the massacre. Proud Gideon and Sarah Juma were indicted by the Pretoria Chamber of the Court, and as a result, they ran to Kenya to hide, not to die. The ICC, through the prosecutor of the court, have requested Kenya to arrest and hand over the suspect to the court to face trial. You work at the Ministry of Interior as the legal counsel. The cabinet secretary has asked you to advise him on what to do on the request by ICC. 3 marks. So, in your course outline, International Criminal Court is there under topic 2. And I thought that it was a fertile ground that can be asked in your exam. Just because the topic is in your course outline, that means it can be asked, even if you did not do in details. And this what CRE usually have a tendency of doing. For example, I told you in 2015, we did not study about banks, and it came in the exams, but it was in a course outline. If you look at November 2015 commercial, you'll see question 2 and 3, it was about on banks. If you look at the conversing that was done in March, the paper that was failed by most students, those questions, they may not have learned in class, but questions like conversion of title, question like letter of allotment. But those are things in conveyancing. They are there in the course outline. So always look at the course outline and look for possible questions that can come. Provided the course outline is as what you has a topic or subtopic, that means it can be asked in an exam. So I thought this is a question. Of course, this question wants you to have an understanding of the International Criminal Code, which tries people who bears the greatest responsibility on atrocities, crimes against humanity, genocide, murder. And you remember this one became very popular in when some Kenyans were indicted by the court in December 2010. And the Kenyan Parliament domesticated the Rome Statute that establishes the International Criminal Court through International Crimes Act in 2008, 2009. International. So you need to understand the International Criminal Court. General have read the Rome Statutes, just overview, not very deep, and then International Crimes Act of 2008, which commenced on 1st January 2009, which of course domesticated the International Criminal Court. So generally it deals with I said genocide, crimes against humanity, and war crimes for the people who bear the greatest responsibility of planning the atrocities. So ICC can request assistance to the country. Of course, Kenya is a signatory of International Criminal Court, and it cooperates with the court, and that's why this act was enacted. Then the International Criminal Court make requests for assistance to Kenya. If you look at Section 20, one of the requests that can be made to International Criminal to Kenya through by ICC is provisional arrest of ICC suspect, either a suspect or person who has already been convicted, which is part of the question we are going to deal with, which I sent. Then the identification and whereabouts of a person, taking evidence, questioning of any person being investigated, service of document, facilitate the voluntary appearance of persons, temporal transfer of prisoners, examination of places or sites, execution of search and warrants, provision of records and documents, protection of victim and witnesses. So a request is made through authorized channels. And it can be made through the minister responsible for interior or the attorney general. And for this, for the question that we are dealing with, the most relevant section is section 28, which if someone has they need to arrest and prosecute for arrest and handover of a suspect who has been indicted by the ICC, section 28 is relevant, where a person in respect whom the pretrial chamber has issued a warrant of arrest under Article 58 of 60 of the Rome Statute. So, after the request is made to the minister, the minister shall be, now section 29(1), shall be satisfied that the request is supported by information and documents required under Article 91 of the Rome Statute, and notify a judge of the High Court in writing. Of course, you make an application request that the judge issue a warrant of arrest to the person whose surrender is sought. So, if you look at the supporting documents under Article 91, which should be sent for with request to arrest someone, now we are trying to answer the first question of that one which I sent. This is a possible question that can come, both as a theory question or a drafting question. So, if you look at Article 91 of the Rome Statute that established the ICC, the documents that should accompany a request for arrest, request for surrender should be information describing the person sufficient, a copy of warrant of arrest, of course, which is issued by the chambers, such document, statement, or information that meet the requirement of surrender process in request of the state, except those requirements that should be more than. So, copy of warrant of arrest, information describing the person sufficient to identify and information, and person probably location, and other documents That is Article 91, 1 and 2. So, question 1, which has 3 marks. Question 1A, which has 3 marks. I'm reading, we are looking at Marianne answer. Of course, he said he used 12 minutes, which is a lot of time for 3 marks. You should use around 8 minutes, because a question of 10 marks, you use 25 marks, so to 25 minutes. So you divide by 3, around 8 minutes. Extradition proceedings for international crimes are regulated by International Crimes Act. After receiving the request, the minister may request court to issue a warrant, arrest warrant, if request is supported by sufficient information and document. A judge will issue arrest when that is satisfied that the person is suspected to be in Kenya and there are reasonable grounds to believe that the person who requested for surrender is. DPP moves to court through a notice of motion. After the arrest, the person is brought to the High Court at the earliest opportunity to determine their eligibility for surrender. The person may be admitted to bail pending determination of those eligibility for surrender. The person is eligible for surrender if the warrant of arrest, the judgment issued by SEC, the person is who the warrant of conviction related, court is satisfied that the person was arrested procedurally, the court is satisfied that the person is upheld. The High Court issues a warrant of detention pending a person's surrender to SEC or discharge and sends the minister a report. The court is required to inform the person that they cannot be surrendered until the expiry of 15 days, that the person may lodge an appeal rate of habeas corpus, that if they aren't removed within 2 months, they can apply for discharge. The minister may either make an order for surrender or reason of the High Court. So, this answer has a lot of things which are not relevant because the question was asking you advising on what to do with the request. And it is 3 marks. So you go straight to say that it's supposed to apply to the High Court for warrant of arrest be issued and be surrendered. And that application must be supported by the documents which you have stated at Article 91 of the Rome Statute. And your answer ends there because it's just 3 marks. You don't need to say a lot of things.
Mwalimu, I had a question.
Yes.
We had a question like this in project work, but then we were extraditing someone who'd committed a crime virtually in Singapore while still in Kenya. So the Singapore authorities were asking us to extradite them back to Singapore. And then so in the act, I think it's Cap 77, that one specifically, it provides that first, after the request comes to Kenya, the Attorney General considers it. After they consider it in consultation, then there is the issue of the authority to proceed, which under the Okemwa case is now issued by the DPP. And then after that authority to proceed is when the court now issues the first warrant of arrest. Then after the person is arrested is when we talk about the extradition hearing and the DPP moves to court through a notice of motion. Is that the same case with ICC?
The ICC is not the same case. And that's why, you know, that is extradition under Commonwealth and non-Commonwealth. The Akina Okemo case, that is extradition if you have committed crimes in a foreign country. Akina Okemo, they are suspected to have done some bribing and they were being sought in Caribbean islands. But in ICC, this is different. You talk about the Rome Statute, then the international crimes. You don't talk about the Extradition Act, both for Commonwealth and non-Commonwealth. Don't confuse the two. Sawa sawa.
Yes, I am understanding that. It's just my issue is that procedure. Because for me, it doesn't make sense why the minister needs to be informed if he's not issuing the authority to proceed to so that the court arrests this person. What is his role now? That's what I'm not understanding. Because even in this one, it talks about the minister receiving, and then the court still independently first issues the arrest, and then afterwards is now when we have the issue of like the hearing to determine the eligibility. Like there's a disconnect in that procedure. It doesn't make sense almost entirely for the minister to even be involved anymore because all the decisions are made by the DPP and the judiciary independently.
You see, in the other extradition, there was a contention for authority to proceed if who initiates. And the Supreme Court, of course, in Okemo case decided that in majority is the DPP. Are we together to that point? And authority to proceed, then you go to court, which now court can give the authority to proceed, these people be arrested or hand over, or they can decide otherwise, which is pending in court for Okemo. Now, after the Supreme Court said what they said, now the DPP initiated authority to proceed for Okemo case again. But for international crimes under the ICC, there is nothing like authority to proceed. Authority to proceed is in the other extraditions. Here, the role, first of all, comes to the minister. And in fact, you can say the power here, the International Crimes Act gives the minister the powers without involving even the DPP to then, of course, the Minister for Interior to, after receiving the request, of course, the request can be made through Attorney General office and the minister himself. Then, if it is satisfied that it has the correct documentation, then he moves to court. And this case is the High Court. You must also know the difference. In the authority to proceed, you go to the magistrate court, chief magistrate court, criminal court, is there in the extradition. But for ICC, you go to the High Court directly, the criminal division. For the judge to issue a warrant of arrest and surrender, warrant of arrest for the person which is required. Then the minister can hand over and also to be surrendered, and the minister can then surrender that person to ICC. Are we together?
Yes, we are together. I'll send another question that had been asked to the group so that you look it over and then give me feedback on it. It was basically a long question, and it was about I think it's a repeated question for Joseph, Connie, and another woman. So Connie was being wanted by the ICC, and then the other woman was being required by Zambia, although she's a Ugandan, but they've both been arrested in Kenya. I'll send you that question, then you can give me feedback on it.
Sawa sawa. This is a very fertile ground for exams, because students may tend to confuse extraditions and the Commonwealth and non-Commonwealth. Those acts, this year they are called what? This extradition Commonwealth countries and extraditions Cap 77, then extraditions for non-Commonwealth country. But ICC is very different. ICC, you talk about the Rome Statute and you talk about the International Crimes Act. So, Ruth, how are you?
I'm fine.
Did you do the question?
Yes, I did. But for me, I didn't answer like flowing, because when the question started asking about the ministry, actually I ended up thinking of extradition. But now, because in the extradition, as Miriam has stated, it's AG and the ODPP. So when I saw the minister, I was like, is it because it's an old act, an old question before? But I didn't know it was about ICC, the procedure. I didn't know about that procedure that you just discussed.
Okay. Oh, sawa. So that is it. You can go to the next question because of time. The next question was now to draft the appropriate pleadings based on advice in A above. And I'm projecting the answer given by Marianne. Uh, 35 minutes. These are a lot of time. You should reduce your time to about 18 minutes or thereabout.
Mwalimu, this question, okay, I to defend myself, I redid this question. That's why it took me so long, because I wasn't sure based on my advice what pleadings I was doing. Because I was just been told that I am an aide under the cabinet minister. So I didn't know if now we are working for, because I feel like it would still be the DPP who goes to court. He's the one who's been mandated to do criminal proceedings in Kenya. So I wasn't sure if we are asking for the DPP, or maybe now we've also advised maybe this accused person. So I wasn't sure again if maybe we're doing writ of habeas corpus. I was not sure.
Yes, let's look at the answer. The answer you have done is correct. To me, generally is correct. You move through a miscellaneous criminal case, and of course the act does not say that, even in the regulations, but if you look at what I'm sharing now in the screen, every time you ask about in criminal matters where the pleading is not you have not been told about the pleading that you use, it is can you see my screen?
Yes, we can.
Yes, this is this is where the cabinet secretary then Kanseri received request from International Criminal Court to hand over Paulo Gesheru, the advocate. Of course, they were for interfering. You remember they were already been indicted by Pretoria Chamber for they were offenses against administration of justice. So when the cabinet secretary then Kaiseri got the request, he moved to court, and it is a miscellaneous criminal application, which is originating notice of motion supported by affidavit. Of course, the court did not agree with them, and the court refused to hand over them. But generally, that's how you move to court, through a notice of motion, an originating notice of motion. So, Republic of Kenya High Court miscellaneous criminal application number, Republic, through, you say here, through the Cabinet Secretary for Interior, Paul Kipyegon, Cyrus Juma, second respondent, second accused. Notice of motion, originating notice of motion. You add that here. Because, of course, you know that notice of motion most of the time, it does not start the cases. It's done through, it's where there is application, but where it has a case, like in this, you say here, originating notice of motion. So you quote section 29 is the most relevant one, 28, 30, and 39 of the 28, 29. I want to see 39 what it says. Yes, it is okay. Then, of course, the article on the DPP, Article 157, that's okay, very okay. 6A, the mandate of the DPP to institute and undertake criminal proceedings. Take note, this honorable court shall be moved.
Mwalimu, you're projecting the International Crimes Act.
Okay.
That's what I can see.
Oh, Sasa, let me. So, you can see now.
Yes, you can.
So, Republic of Kenya High Court at Nairobi Miscellaneous Criminal Republic, through the Cabinet Secretary for Interior, is the applicant, Paul Kipyegon, first respondent, first accused, Cyrus Juma, second respondent, second accused, notice of motion. This section are okay, all of them. Then you got take notice that this honorable court shall be moved on. 7th day of October. Because the day of the exams is not the day the court shall be moved. Don't indicate the data 7th, because when you are told to draft, when you draft, it's not the day the court shall be moved. So you leave blank there. Are we together?
Yes, Mwalimu.
But you date the day you draft, which is the day of the exams. So in the forenoon and thereafter for hearing the warrant of issue begins the accused person. Upon a deprivation of the accused individual for surrender, the accused person be surrendered to International Criminal Court. That the Honorable Court make such other orders as be deemed fit, necessary, and expedient in the matter of justice. Which is application is based on the following grounds. That the extradition request was issued by International Criminal Court through the prosecutor of the court, that the indictment of the accused person by trade chamber of the court, and the further grounded in an next affidavit of you see, the person who moves to court, if you look at section 29, most of that is the cabinet secretary. It's not you, it's the one who will move the court. So even in this case of Paul Geshero, if you look at this, they were talking about the affidavit. And the affidavit deposed by Major General retired John Kaiseri. So it is the minister who swears the affidavit, not the council. So you says the affidavit here of cabinet secretary, and you put the cabinet secretary, which is now who is there, who is called Professor Kidhuri Kindike. Then you date supporting affidavit. If a question is 7 marks or 10 marks, after you draft your pleading, you make your supporting affidavit very short, because supporting affidavits just restate the facts that are there in the question. So you can say here, I, Professor Kidhure Kindiki of ID number PO Box in the Republic of Keduha, state as follows. That I am the Cabinet Secretary responsible for Minister for Interior. I have gotten a request from ICC with supporting documents, and I'm satisfied that the requirements are met under the Act. Then you go straight to that what is stated here in above, and that I swear the affidavit in support of the application for warrant of arrest. That what is stated here in above is true to the best of my knowledge. Are we together, Marianne?
Yes, we are.
So it is, if you are given, if it is a question of 10 marks, I can tell you after drafting the pleading, you have very short time to do a supporting affidavit. So you go straight after introducing the person who is swearing affidavit, you go straight. Because if you do all these things you have done here, you not have time. It is not worth the time that is given, the marks. But if it is a question of 15 marks or 20 marks, now you are supporting affidavit may be very substantive. How did you do this question, Ruth?
I actually did it as an extradition.
It's not
for
an
extradition.
It's not an extradition.
Then yes, that's what I've learned. It is more of an ICC.
Yes, it is ICC. It is originating notice of motion. How Marianne have done here. So we go to the next question.
But Mwalimu,
yes.
I think for Marianne, it's important this place for drawn and filed by.
Okay.
I'm seeing as if hers are missing.
Drawn and filed by?
No, up. see, like for notice of motion has its own and supporting affidavit has its own.
You see, another thing, I told you in an exam of, for example, if you are given, you saw they usually ask you 5 marks and 10 marks to draft these things. I know you have seen those questions in criminal, civil, legal writing, and drafting. Because you want to save time on these pleadings. After you do the heading, which is Republic of Kenya, and you do the parties, then notice of motion. Then after you do the pleadings, and further grounds are next. Then you can date it at Nairobi. You don't need, for supporting affidavit, you don't need again to start giving the Republic of Kenya and parties, because you don't have that time. And then now sworn by the said affidavit is very, very important. Before me, Commissioner, drawn and filed by, now that the drawn and filed by is very, very important. When you are finishing your pleading here below, to be served upon, this is what you are saying.
Okay, the way I did it after the notice of motion, and I've go to the notice of motion, just go up. Where she starts now after giving, just go down now to the end of the notice of motion. Here, now after Nyambura Njero, which I think should be, yes. Now there I wrote, drawn and filed by. Then I went to the supporting affidavit.
And then is supporting affidavit, again you say drawn and filed by.
Yes.
It's not necessary. Because it's not necessary, because you do not have that time to do those things. For a question of 15 marks and 20 marks, you can do that. But for a question of 10 marks or 5, you avoid repeating.
Oh, okay.
After you do the heading, you can go dated. In fact, even this dated, you can remove it here. And even Nyambura Jairi, you can go straight to the supporting. Then after finishing here, you say dated at Nairobi, this. Then you say drawn and filed by. But you don't date and you don't date a supporting affidavit. So dated at Nairobi, you date the pleading. So the way it is here, it is okay. Then you sign as a prosecuting counsel. Then you could come to the supporting affidavit. Then sworn and said by, that is very, very important. Before me, Commissioner for all, sworn and on said by, because you are drafting that day. So this is very correct, 7th day of October 2020. This dated, you also date, because that is the day you are drafting is the day you date. You date at 7th day of October 2023. Then you say drawn and filed by here to be served upon. That you missed, Marianne.
Yes, sorry.
Yeah, you to be served upon. First accused, of course, you say Paul is called this person, Paul Kipyegon. Then
I have a question.
Yes.
If you do not know where they are, that is where you want a warrant of arrest. Who exactly are you serving?
Sorry?
If you do not know where they are, that is where you want a warrant of arrest. Who are you serving?
You know, You know, this question already you have been given by ICC. The warrant of arrest has to be issued to
the court.
To against Paul Kipigon and Cyrus Jumba. In fact, warrant of arrest are usually done ex parte. So it's not, you don't need to say to be served upon.
Okay.
Yeah, so this is okay. You don't need warrant of arrest are usually issued ex parte. So you don't need to put the to be served upon. Sawa sawa. So I think we can go to the next question. Which I am projecting, I hope you can see. On the night of 22nd September 2023, Musa Joma was robbed of phone and cash as he was going home around Marava Road, Busia. The road had, this is not have had street lights, and clearly remembers how the robber who robbed him looked like. Musa Juma reported the incident to Busia police station, and the next day he was caught by police officer in charge of the case. He was told that the same night the officers as here on patrol had arrested a person resembling the one he had described. He was told that he would appear at the police station on 3rd October 2023 to identify the suspect in an identification parade. As officer conducting the parade, what step would you take for the identification parade to have good evidentiary value in court? So this question needs you to have the knowledge on how the identification parade are usually done. And this is question have been tested, but what I wanted most for you is part B, which has not been filling in the form 156, which has never been tested, and which can become the question. So let's start with I want to start with the answer that Marianne gave. This is drafting. It's very rigorous. If you understand drafting in criminal, in civil litigation, in legal writing and drafting, you'll be good to go. Drafting is a skill. Let's see. Marianne, you can be reading the answer you gave in 2A. As my laptop opens,
So 2A was yes. 2A is the procedure for conducting IP identification parade. So I wrote, the procedure for conducting identification parades is governed by Chapter 46 of the four standing orders and justified in Republic versus Mwago. So prior to the parade, the witness is requested to give a description of the accused before taking part in the parade. The accused should be informed of the reason of the parade and that they may have a solicitor or a friend when the parade is being conducted. The accused is also informed that the procedure is voluntary and they may refuse to participate, and this response is recorded. The witness should not be permitted to see the accused before the parade. Of the case may be present but cannot conduct the parade. The accused person should be placed amongst at least 8 persons of similar age, height, general appearance, and class of life as the accused. If the accused is suffering from a disfigurement, steps should be taken to ensure it's not apparent. The accused will be allowed to take any position he chooses and will be allowed to change position after each identifying witness has left. The witness is allowed to direct the accused to walk, hear them speak, or act in a particular manner. But in this event, the whole parade should be asked to do the same. The accused is also required to comment on the fairness of the parade, and their response is recorded. The police, while explaining the procedure to the witness, should use neutral terms as not to direct the witness. The police should record whether the witness identified the accused and in which circumstances. They should also record comments by the accused. The procedure should be done with unscrupulous fairness. After parade, officers should do a report in Form 1 P156.
Yes. I think that is a correct answer. And that's why I give it 10 marks for all those things that you have said there. It says the same thing what was your answer, Ruth?
It's basically the same. The only addition of just say was, I don't think she said about the minimum number being 8. And then
she said
the witness has to touch the victim.
She said that one, eh?
Okay, don't know, I wasn't writing. And then okay. And then did she say about the complainant must touch the suspect?
Yes. It must show clear. She did not say that. Did you say? I did not hear. He must.
I can read.
He must identify the person he suspect clearly. I don't think she said that. So that is an addition. Okay. I don't think that was a very difficult question. It has been tested in the past. So we go straight to question 2B, which says that now you do the report as the person who is conducting, and I'm projecting Marianne's answer. I hope you can see it. Sometimes this, okay, the laptop misbehave. So, Police Form 156, the Kenya Police, Chapter 46 of the fourth standing, report on notification when Busia Police Station on that October 2023. Case file number, offense, is robbery, investigating officer, you give your name. This is the facts I was said. I usually tell you in the question will not give you all the facts, even the names of people. It is for you to feel. So robbery with violence, robbery. Then investigation officer, Atamire rank constable, officer in charge of the parade, Atari Mengo, rank chief inspector, station Busia. Name of the suspect. That was not also was not given. So you look for name, address of the suspect. Suspect was the purpose of the fight. Yes. Suspect consent to appear at the parade and press there to yes. Signature of the suspect. Inform that if so desired, friend of solicitor may be present. You put here Kenya because we don't have solicitor. You put an advocate. He prepares there too. Name of the address of the advocate or friend. Signature. Witnesses. Name. Musajuma Mamboleo. Then because this Musajuma was robbed Arun, okay, maybe there is someone who saw him being robbed. Is okay. Mamboleo, P. Box 81, Malava, members of the parade. You put members of the parade. Kenneth Bire, Anthony, give your box number, which should be at least 8. Francis Koiri, Martin Odige, Jonathan Mudavadi, Jeremy Alele, Isaac Juve, Albert Smew. What objection, if any, made by suspect concerning the arrangement of the person to the parade? No objection. What action? What was the action taken by objection? Then you look at the result of the parade, party, witness number, position of the suspect on the parade. For the suspect identified Suhwai between Jeremy Alera and Francis Kizito. Was the suspect identified as Suhwai Sweswe identified by Twitters by touching? Witness 2. Of course, between Albert and Kenneth Bwire, suspect by touching. When the suspect was asked if he was satisfied with the prospect, yes. The suspect was satisfied with the process. Signature of the suspect. Certificate of the officer conducting the parade. I conducted the whole of the proceedings in connection with the parade. And I certify that the instructions on the IDPRs were strictly complied with to the end, and that far as possible, the persons taking part in the parade were of the similar age, height, and general appearance with the suspect. Dated that 10/2023, signature, Hatari, rank of the inspector. This is okay. And let me see your Ruth, you did this question?
No, I didn't fill this form.
You did not do.
Yes, I didn't fill the form.
Yes. In an exam, you do not be filling the form. In practice, is a form, you fill. But in a question, in an exam, no one will bring the form there and tell you to fill. And he draws a form there and tell you to brief, to fill. It is for you to draft practically. the way Ruth have done, and the way Marianne have done. So it is for you to cram these parts, and this is a possible question in an exam. So it is very, very, very important to know this, to know how to draft this thing. And in online, you find people who are drafted. Course Hero, you know Course Hero. You can pay you can go online and pay the subscription, and you see there is a form there in case that drafted. Which look like the way Marianne have done. You know, drafting, unless you do practically, just by looking, and it may not help. So I think that was a good trial. Then we go to the next question. Let me civil litigation court outline. Next question, I think I told you to draft. That's question 2, of course, was dealing with the topic of identification of parade. If you look at your course outline, then question 6A, question 6A, July 20, question 6A, August 2015. Which I'm going to read right now. I hope you can see the screen. You can see the screen? Question 6A, August 2015.
Yes, we can.
Okay. Kamau, Mutinga, and Ochieng are close friends. On 20th day of 2014, they went on a robbery spree in Kiambu. They went to the house of Mwangi in broad daylight and stole 5 TV sets, 6 mobile phones, a gas cylinder, and left before the housewife could spot them. However, they were not lucky, as neighbors saw them and raised alarm. Members of the public gave chase to Kamau and was arrested and handed over to Kiambu police station. 3 phones were found on him. The other gangsters fled in a speeding Subaru car. As Kamau was being booked, the police found 3,000, a leather wallet, and pen knife on him. The house girl, one Nyambura, later reported the matter to the police. On the same day, at 3 p.m., the robbers struck at Kiambu Coffee Factory, where they ordered women to lie down. A shaking Mombi disobeyed orders to lie down and was hit with a panga on the head, sustaining serious injury. The robbers stole 10 computers and 200,000 from the factory. On their way out, they shot in the hands to scare onlookers. The factory manager reported the matter to the police. One IP Mutea was assigned the case by OCS SSP Odhiambo to investigate. Investigated the scene and drew sketch map of 2 scenes. He corrected documents of ownership of the items stolen. He recorded statement of the key witnesses. During the investigations, IP Mutea got some wise leads, resulting in the arrest of 2 remaining robbers, Mutunga and Ochieng. He used an identification parade to be conducted by P. Mutua. Both suspects were picked out by the witnesses. Charges were then proffered upon them. A pistol found on the chain was taken for ballistic analysis. A report from ballistic expert was received by investigation officer. Required. Assume you are the investigating officer. Prepare a complete police file to enable OCS to decide the way forward. So, this question was testing you on topic 5, preparation of files for trial, which can come. Content. This was testing on content of a police or prosecution file. You can be asked to prepare an advocate's file. It has been asked as a theory question. And you can also be asked to prepare a court file, both as theory and the contents of a court file, both as a theory question or drafting. And this is some of these questions which requires you to be very creative in what you in your drafting. So you need to know the contents of the prosecution file. And then you cannot do then you can be able to do you can now be able to draft the prosecution file. So I'm projecting the answer given by Miriam. Of course, this question was 10 marks. So you should be very, very quick in your drafting. Because these sub-file are very many, and you need to be very creative in what you are doing.
Mwalimu, I wasn't sure what it means by drafting the police file. So initially I'd started even writing like the complaint by Nyambura, but then it didn't make sense for it to be 10 marks and you have to draft all those reports. So do you just, when it asks you, do you just apply the question in describing the sub-file, or are you supposed to actually create them? Because we did that in class and it's a lot of work for 10 marks.
You see, CRE questions that do not make sense. CRE questions do not make sense, but the way the question is brought, you should do the way it has been brought. You see, I've told you that an exam does not only test you on on it does not test you on the content. It usually tests you even on how fast, because this question, this exam is 3 hours. There is a question in June 2021, criminal. The question was 5 marks, and you are supposed to draft a pleadings to quash the charges. And of course, you can do a petition, or you can do a judicial review application, but the answer, the marks given there did not make sense. But that is a CLE for you. I'm preparing you for this. I'm preparing you for these eventualities. Of course, when you are told to draft a prosecution file, this is a question that should be 20 marks. It is not a question that it should be it should not be 10 marks, but that is theory for you, and be prepared for such kind of a question. They can come. I'm opening the theory question. The theory question was in, it has been asked many times. The last was in 3 in August 2015, context of prosecution file. Of course, subfile A was initial report. It is an initial report made by the complainant. Also, if you look at the notes area, in your civil litigation, I uploaded the sample, which we also did like you when we are there. And that is what I want to open, so that we compare with your with what you have done. Of course, this question requires you to be very, very, very creative. Sample prosecution file. This I hope you can see it on your screen. Can you see?
Yes, you can.
Yes, so subfile A is the initial report. The complainant made by the person which of course is recorded in the occurrence book. So initial report, a question of 10 marks. Of course, we have said a question of 10 marks should be done within 25 minutes. So you don't say a lot of things, because as far as you after you have identified the file, subfile A, initial report, you do the occurrence book, because this initial complaint is made in the occurrence book, as you can see, and the occurrence book extract, you know, is a copy of the occurrence book. You say number, reference, our case file, nature of occurrence. You say according to the question, what happened, when he reported to the police station. We are told that Nyambura reported the matter, and also this person, factory manager, reported the matter. So you draw like a table, as you can see in there, that sample I've showed you. So you say that reference hour, the time you create, then case file number, you draw like a table. A complaint by Nyamba also occurred that on 20th, men occurred whose set 6 mobile and 2 glasses. A complaint was made by Mubi Factory. A complaint was made by Kizito Mali of Kofiam. So the only difference here is that you occurrence book is like a table. Marianne, are we together?
Yes, we are, Mwalimu.
So you draw like a table here, right? This information here, you draw like a table that is here, sample occurrence book. Then you go to the subfile B, which is sketch.
Please project the OB.
I want to, this one, it is in the notes. You see in the notes.
I just want to, I'm adding to my notes. I just want to read that part.
Mm-hmm.
Okay, thank you.
Okay, sawa. So, you draw like a table. Now we go to subfile B, which is sketch plan and documentary exhibit. We are told that SSP one we are told in this question that he visited the scene and drew a sketch plan of the two scenes, both for the factory and both for this house, this police officer. So, in your question, you draw a sketch with your biro. That is very easy. Say this house look like this. Just something to show that you have drawn a sketch. Eh? And then the factory, you draw a sketch. Are we together?
Yes, Mwalimu.
Here you didn't draw anything. We go to sub-file C, which is expert report, post-mortem, government analyst. Sub-file C contain expert reports. In the course of investigation, number of tests and accusation are done. The investigation officer will file the exhibit memo form and take exhibit in question of an exam. In the question for examination, the exhibit memo form and expert reports are filed in this sub-file. Expert reports include doctor's report, postmortem report, ballistic report, document examiner, government analyst report, and explosive expert report. Each report is accompanied by expert statement. I'm reading page 189 of 2008 to 2019 Q&A. So in this question, you needed to, because the question tells that the ballistic, there was a pistol that was taken to a report from ballistic expert was received. So you say ballistic report of this expert. You say I have this background in this education. I examined this pistol number, this, and I found that maybe this bullet that was used and emanated from, yeah. Then you sign your report and you put here under sub-file C. Are we together, Marianne?
Yes, Mwalimu.
Yeah, you didn't put anything under sub-file C. Then we go to sub-file D. Sub-file D contains statement of the prosecution witnesses, which is easy. The prosecution witness here is that person, those people, the factory manager, and that house girl. You draft very quickly the prosecution witness statement, which you can see I am projecting here, and under this, I hope you can see sub-file D. I honored address I reside in. It just gives the story of what happened. Each of course you will get from the question, which you do the statement of those two people very quickly, because these are 10 marks. Of course, this is a question that should be given 20 marks. Don't be surprised if it comes in your November exams as 20 marks, the compulsory question. You do the statement very quickly, and then you go to sub-file E. Subfile E contains charge and cautionary statement, statement at the inquiry, statement of the accused, the investigation officer will interrogate the suspect on the alleged offense. So the statement of the accused now come to subfile E, and he will warn him that anything he says will be used against him in court. Then he will you draft the statement he says. Of course, they will deny the crime. So you become creative and create the statement. Then you sign. You can look at this file later. It is uploaded in criminal litigation notes on the website. Then you go to the next subfile, which is subfile F, which contains the investigation diary of the investigating officer. You will interview the witness suspect. You will visit the crime scene, hospitals, mortuary, offices, prison, crime scene, where he went when he was investigating. So you become creative. For example, in this question, of course, he went to the crime scene of both the house and the factory on different dates. That will be investigation diary dated around. So it will show, it would include the places he visited. That is subfile F. Then let me see what you did in subfile F. Subfile F. The investigation with interview witnesses and record all the inquiries. The IP also record his movement in such a case, visited the scene. So here you put like a diary. On this and this day, I went to the house of this Mwangi, bra. I interviewed the house help. I interviewed the owner of the Nini. On this day, I went to this factory. The next day at this time. That's how it should look like. Then subfile G contains the copy of the charge sheet and related documents. Of course, you draft a very quick charge sheet. You know how to draft a charge sheet. If you look at copy of charge sheet, if you look at one there, you put the names of the parties, the names of the accused, then charge one particular statement and particulars. Very quickly, that one you copy of charge sheet, you did not do, you draft practically, because this is not a drafting question. This is a drafting question, not a theory question. It is not asking you the content, it is asking you to draft. Are we together, Marianne?
Yes, we are, Mwalimu.
So that is subfile G. Then you go to subfile H. Contains previous records, list of exhibits, list of witnesses. Contains accused previous record, list of exhibits, list of witnesses. The fingerprint form of the accused will be placed in this subfile. The accused will also be In this file, the prisoner's personal effects will be listed here. Documents, wallet, shoes, money, inventory of the accused, recovered from the accused or his home or place of arrest related to this case. So, list of witnesses, list of exhibit. If you look at this subfile H, subfile H, list of exhibits, list of witnesses. So you say prosecution list of exhibits which are they got from the suspect, which are there in the question. You then put prosecution list of witnesses, which of course they are there in the question. Then you go to subfile I. Subfile I is a covering report. This is a report by the officer in charge of investigation, giving the chronology of event and conduct of investigation culminating to the decision to charge a suspect and arraign them, arraign them in court with specific size. The investigation officer, in giving the finding, will cross-reference with relevant witness statement and exhibit. So here is a report of the investigation officer, covering letter, you dated covering letter. If chief, the officer, he gives all the story, what happened, and he could reference. For example, he says that I investigated on this day, these people were arrested, we recovered this, and his reference from the other subfile, which I've already said, that these people with were arrested with these items. These are the prosecution witness. So that is a covering letter. Then finally, is subfile J, which contains minute sheet. The subfile contains the correspondence between the police personnel and the state council handling this case. So robbery with robbery crimes, you can see what I'm projecting. Republic versus the 6 above names are suspect in series of, and he gives the suspect the nini, the crimes he wants to charge them with. Then we seek directions to take in regard if you could charge the 6 suspect with the offense of rape. Of course, in the question is robbery with violence and theft. So, subfile J, that is it. That's how you draft. And Miriam, you did this as the theory question, except for A. The occurrence book, but you did not do like a table, an extract, because it's an extract. But others you did like you are doing a theory question, describing what is the content in any subfile. You can be told to draft in an exam, either a prosecution file, an advocate file, or a court file. So it's for you to be prepared, because it's in the course outline. Don't be caught unawares. Ruth, did you do this question?
Yes, I did, but as theory.
As theory, you draft. So practice in your free time. Practice. Of course, the content of our advocate file have been asked previously. And the content of a code file, I don't think it has been asked. But you can also be told to draft. If you look at, when we are looking at conveyancing and commercial, if you look at those kind of drafting that we are being asked or questions, some of these questions have been asked, being repeated. We are asked very early in, I think, 2008. So if this question was asked in this year, 2015, it can be asked again. So be prepared. Be prepared. That's what I can tell you. Because if it is in the course outline, it can be asked. So we go to the next question.
Mwalimu, I'm not disputing it can be asked. I'm disputing the amount of work that needs to go. Because, like, for instance, there's another, I think the fifth question we're supposed to do was a charge sheet. That charge sheet by itself was 10 marks. And they're asking me to do a sub file, which will include a charge sheet inside. And overall, they can only give me a maximum of 20 marks. It's the mark load that is the issue. Unless maybe I'm supposed to draft like a specific sub file, you know. But if I'm drafting all of them, I cannot see unless it's the whole question paper for 60 marks.
I'm saying, I told you, theory question do not make sense. Are you getting? Theory question do not make sense, but they will be asked anyway. I agree with you that this question is supposed to be 20 marks. If they ask it, but it was asking that they gave 10 marks. So it is for you to be very, 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 very creative and very quick in what you are doing. So I think we can go to the next question. Sasa?
Yes, Mwalimu.
Yeah, we can go to the next question, which was, we are going to do it very quickly. The others we are going to do, I think that will be our last today. Then the other one we are going to continue on Tuesday. Tuesday is a public holiday. I'm going to add you more questions to draft. Question 2, July 2018. Let me open the paper. July 2018 is opening. So, this is question 2, July 2018. John Mapesa. You can see it, eh? You can see it on your screen, eh?
Yes.
Yeah. John Mapesa and John Musete operate a joint business under the name Messiah Joe Jeans Enterprises. On 4/2017, they approved Sukari Company Limited intent on supplying sugar from Mumias Company Limited. They had with them 2 tender documents from Mumias Company Limited, which they showed officers of Sukari Limited when they visited them at their offices at Industrial Area, Nairobi. Officials of Sukari Limited, on the strength of the document, placed an order of 8,000 bags of sugar. They also advanced Georgine Enterprises half of the purchase price being 800,000. John and G failed to supply the sugar. They declined costs and the funds which eventually went off. They went underground. The matter was reported to Industrial Area Police Station. The investigation led to Chief Inspector Hatari revealed that the documents presented by John and Jean were forgeries. John and Jean are eventually arrested at Namanga and police plan to arraign them in court on 10/7/2017 to answer charges of forgery contrary to Section 349 of the Penal Code, uttering a false document contrary to Section 353 of the Penal Code, and obtaining money by false pretense contrary to Section 331 of the Penal Code. Required: prepare the charge sheet. Prepare the charge sheet. Complete the charge sheet is topic 6 of your course outline. Eh? And there are many theory questions in the question you'll see. But in this topic, the question that you can be asked is to draft a charge sheet. You can be told to amend the charge sheet, or you can be asked to coach the application to coach a charge sheet. Those are the practical drafting questions that can be asked. And charge sheet, drafting a charge sheet was coming as almost like a compulsory question in the past. But now they don't ask it, but they can still ask. And you have your penal code in your exam room. That is the essence of your penal code in the exam room. For you to quote the section with in the statement of offense, you quote the section very well, very clearly. So I want to see what you did. Question 4. Question 4 charge sheet. So Marianne says that he did this question with 20 minutes. Which was okay, which is 20 marks, which is 10 marks. And the question, a question of 10 marks, you should use a maximum of 25 minutes. So that is how it should be done. So you are within time here. I want us to stop here. Let's start the next. Let's start next time from this question 4 and 5. I don't want us to rush, because this is a very, very, very important question. So I don't want us to rush. Let's look at this answer next time, and the other question 5. And I'm also going to add you another 2 or 3 questions for next time. You're going to meet on Tuesday. Tuesday is a public holiday, so you have time to draft. I'm going to send you the question today before the end of today. So we are going to look at these answers next time, and another like 2 or 3 questions. Because I don't want us to rush. I want you to get this this drafting very well. Are we together?
Yes, Mwalimu, we are together.
Are we together, Ruth?
Yes, we are.
Yes, I don't want us to rush. If I start doing right now, the time went. And I want you to get this question very well, because charge sheet drafting is a very, 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 very important question, which can come on how you are supposed to draft.